So, good afternoon, everybody. Welcome back to the last session of the International Conference Genome Editing in Europe, New Agenda on New Disputes. This is actually the second part of the session 4 with the title Regulation of GMOs in the EU and worldwide. My name is Johannes Fritsch. I'm from the Leopoldina head office, and I will be the host of this session. We will now hear more about GMO regulation in the Western Hemisphere with a focus on the genome-edited plants, as in all the conference. And yeah, as in all sessions before, the public audience can ask questions in the Q&A section, which is on the lower part of your Zoom window. And we will try to sort and summarize the questions in the end of this session and address these to the panel. And with that, I'd like to hand over the session to the chair, Professor Hans-Georg Dederer, who is chair of Constitutional and Administrative Law, Public International Law, and European and International Economic Law at the University of Passau in Germany. We've heard from Professor Dederer before in session 1 and 3, and he's also, or has been a member of the interdisciplinary experts working group of Leopoldina, the German Science Academies, and the German Research Foundation that published this statement in the end of last year. It has been mentioned before. It has actually the title Towards a Scientifically Justified Differentiated Regulation of Genome-Edited Plants in the EU, and provides very concrete solutions how to deal with these problems we are tackling during this conference. And hereby I give the stage to Professor Dederer, please.
So thank you very much, Dr. Fritsch, and welcome to all of you to our last session, that is part 2 of session 4. Concerning regulation of genome-edited organisms in the EU and worldwide. Well, today, or in this afternoon session, we will hear 3 distinguished experts from Argentina, the United States, and Canada. 3 very interesting countries as regards the regulation of GMOs, genetically modified organisms, but of course also genome-edited organisms. Argentina claims to be the first country, or the country which was the first country to adopt legislation or regulation that is specific or was specifically designed to regulate genome-edited organisms. So we are very glad to hear a very brief country report from Argentina by Martin Lema. And we'll also hear a very brief introduction to the US regulatory system by Peggy Grossman. The United States is claimed to be a country which based its biotechnology regulation on the so-called product approach. That leads us back to what Piet van der Meer said in the session this morning. In the end of the 1980s, last century, there was a big discussion how to regulate genetic engineering in the European Union. And one approach was the process-based approach, and one approach was the product-based approach, and was always claimed the United States follow a product-based approach, whereas Europe follows a process-based approach. But when we go into some more detail, then we will see that this is not really a black-white distinction. It's somewhat nebulous. If we go into some detail, we will see in Europe that the regulation is also a little bit product-based. And when we look into more detail into the US, I think the regulation is also a little bit process-based. Canada claims, I think, to be the country which has a real product-based regulation, a real science-based and product-based regulation, and this is due to the regulation of seeds, which and the trigger for regulation is novel trait. So we'll be really interested in getting information on the Canadian system by Stuart Smythe. So I think we should start after this very brief introduction, our talks. The first speaker will be Professor Martin Lehmer, who is professor in the Biotechnology School of the National University of Quilmes in Argentina. What is very important is that he has also experience as a policymaker in agricultural biotechnology. So he was and is heavily involved in actively regulating genetically modified organisms and also genome edited organisms. Please, Martin, the floor or the screen rather is yours.
Thank you, Hans-George, and I would also like to thank Leopoldina for this opportunity. And hello, everybody. Now I'm going to share with you some of the Argentine experience in the regulation of gene editing applied to agriculture. So, first of all, our approach, that's it. First of all, our approach, the core of our approach is based on the LMO definition of the Cartagena Protocol, which is also the GMO definition for the Argentine regulation. These are the two main definitions in the Cartagena Protocol explaining what is an LMO and therefore a GMO for us. These definitions had a lot of redundancy and some aspects that are not relevant to this discussion. So the most important part of them is highlighted here. And if we can compact these concepts, we end up with the conclusion that a GMO or an LMO is an organism that possesses, first of all, a novel combination of genetic material, and that novel combination of genetic material has been obtained through the use of recombinant DNA or the direct injection of nucleic acid into cells, as well as other considerations that may be relevant in some cases. So with this in mind, we can produce like a map where in 2 dimensions we plot the different technologies that use molecular biology in one way or another for the genetic improvement or breeding of new animals for animals, plants, or microorganisms for agriculture. In this map, you can see on the horizontal dimension different degrees of change to the DNA sequence, from techniques that doesn't change the DNA sequence at all to techniques that generate the insertion of a piece of DNA, a foreign piece of DNA. And in between, of course, you have techniques that only make small mutations. And then on the vertical dimension, you have techniques grouped by the different usage of recombinant DNA. Some techniques do not use recombinant DNA at all in contact with the organism. They use them as a satellite activity, but not the recombinant DNA is never in contact with the organism. Then some techniques do use recombinant DNA in contact with the organism, but it is not present in the final product. And finally, we have technologies that do integrate foreign recombinant DNA in the organism. With this, we can, as I said, map the different technologies, and this helps us to draw a line between what would be a GMO or an LMO, taking into account the two rules of these definitions, novel combination and use of recombinant DNA, and techniques that may not be considered LMO or GMO. So with this core criteria, we developed an analysis and decision-making process that is summarized in this slide. We take into account if the product has been developed with the use of molecular biology or recombinant DNA as a trigger for the developer to approach the government and ask the government if the product is considered a GMO or not. So the last part of the decision-making process or the central part of it is to decide if the product has a new combination of genetic material or not. This decision-making process can handle both final products that are completely characterized and ready to enter the market, or products that are under development. And it also creates a communication between regulators of GMOs and regulators of conventional products that somehow mind the gap between these two regulatory systems. This graph shows us how Argentina has been taking major decisions on biotech organisms for agriculture over time. In blue, you have the approval of GMOs since 1996, mostly crops, but also some GMO vaccines. And as you can see, it is always increasing at a certain variable speed. But then in 2015, we had this new regulation for genome edited enacted. And 2016, we started to take decisions pertaining if products modified by genome editing were GMO or not. And the amount of decisions is increasing more steadily. So not only because it's easier or it takes less time to determine if something is GMO or not, compared to the safety assessment of a GMO, but also because we have far more applicants presenting their products. If we analyze the products from new breeding, the so-called new breeding techniques presented to this regulatory mechanism, as you can see in the pie chart here, most of them are gene edited, but there are some others that have been modified by other techniques, like for instance, epigenetic modification. If we group them by trait and by the biological kingdom, we can see that there is a lot of diversity in both dimensions. I mean, we have products in animals, plants, and microorganisms, and also quite an interesting distribution between different kinds of traits for different purposes, traits for basic agricultural interest, traits for consumer preference, for industrial use, very varied. If we compare to the universe of GMOs that have been commercially approved, that's the graph on the lower right, you can see that the diversity is much reduced, no animals, few microorganisms. And as regards to crops, mostly we have blockbusters. This is maize and soybean with herbicide tolerance or insect pest protection. We call them blockbusters because these are products that can be sold almost anywhere in the world to farmers. They can be sold to farmers almost anywhere in the world. And that's mostly the kind of products we get in the GMO universe. But in the gene edited or new breeding techniques universe, we get a more important diversity that could also deliver new technologies to some agricultural chains or production chains that are local or of lesser dimension. Here is a comparison of the applicant's profile. On the right, you have products from new breeding techniques, which are mostly genome editing. And as you can see, more than half of products are coming from Argentine public research or Argentine biotech companies. And pertaining the other half, most of that other half is coming from abroad, but for medium enterprises. And of course, the system is not excluding multinational companies, and they are present to a certain extent. If we compare this to the profile of applicants for GMO products, the situation is completely reversed. Historically, we have only the deregulation. In Argentina, as in many other countries, we have the deregulation of multinational companies, and it's very difficult for local developers and national researchers to deregulate a product. So these are a few examples of these Argentine developments that came to the Biosafety Commission, to the government, and the government say this product is not GMO. This is an example of coming from our National Institute of Agricultural Technology on crops. This is a startup company that was created in Argentina solely to develop genome-edited crops, because the regulation in Argentina and some neighboring countries is working in the same way, open to have clarity on the status, legal status of these products. And also we have now, we have here in the screen an important Argentine seed company that didn't have until now biotechnology of its own, but now it has invested in having a biotechnology, molecular biology lab in order to develop gene-edited varieties of its own property. In here, we return to the National Institute of Agricultural Technology. They are also working in gene editing of animals, in this case for a consumer benefit trait. And this is another example from a medium Argentine company that historically has been working on assisted reproduction techniques, and now it's using that capability to also develop genome-edited animals. And perhaps in a moment, I skipped mentioning something. You may perhaps you saw a map in here, sorry. In here, you can see a map. In 2015, coincidental with the timeline, in 2015, only Argentina had this kind of regulation in the whole world. But now, 5 years later, another 7 countries in Latin America have very similar regulations, and they are also taking decisions. We have decisions like the one I have described right now in Chile, in Brazil, and last week, I think Colombia announced that they have decided that genome-edited rice is not a GMO. So this is the current situation in Argentina and succinctly in the rest of Latin America. Thank you all for your attention.
Thank you so much, Martin, for this excellent presentation and overview. A very good brief introduction into your regulatory system. So I would like to introduce the next speaker, actually, from the United States, Professor Margaret Grossman, who is Book Chair Emerita and Professor of Agricultural Law Emerita in the Department of Agriculture and Consumer Economics at the University of Illinois. Well, Margaret actually published extensively, not only in agricultural law, but of course also in agricultural biotechnology law. And so we're very happy actually to have you here as the leading expert, I would say, in the United States on agricultural biotechnology law. So please, Margaret, go ahead. The floor is yours.
Thank you so much. I'm very glad to be here this afternoon and appreciate being invited to this conference. I'm going to talk about GEO regulation in the United States, but I want to start with some regulatory background and then I'll focus on new regulations that were enacted just this year. So our regulation of GMOs, and we're referring to it as genetic engineering now, dates from 1986, and the focus was rDNA technology. Authorization comes from the United States Department of Agriculture, the Environmental Protection Agency, and the Food and Drug Administration. And we're going to focus today on the U.S. Department of Agriculture, the USDA. Okay, so the U.S. Department of Agriculture works from an organization called APHIS, the Animal and Plant Health Inspection Service, and its biotech regulatory services. The Plant Protection Act authorizes the regulation of plant pests. So one of the focuses is the GE, a plant pest. The regulations dated from 1987, but now we have a new rule. It's called the Secure Rule from May 2020. The Secure Rule refers to sustainable, ecological, consistent, uniform, responsible, and efficient regulation. And again, the focus is on plant pest risk. And I've put a little definition there. The plant pest is any living plant and other things that can directly or indirectly injure, cause damage, or cause disease in a plant or plant product. The regulations are at 7 Code of Federal Regulations, and they're phased in between August and the 1st of October 2021. And the definition of genetic engineering is broad. Techniques that use recombinant, synthesized, or amplified nucleic acids to modify or create a genome. There are a number of provisions of these rules: applicability, scope, definitions. There's a regulatory status review that's important, permits, and some other provisions. And we'll focus on applicability because that's where the new rule focuses on GEOs. So this shows how this system works very broadly. There's a system of exemptions and confirmations. There's a regulatory status review, and then there's a permitting system. And this slide indicates sort of the impact of each of these various stages. And what we're going to focus on mostly now is the exemptions and confirmations that govern the GEOs. This is on the USDA's website, so it's easily available. So in the 2020 rule, GEOs constitute genetic engineering. It's really clear. APHIS has never taken the position that genome editing does not constitute genetic engineering because that would be inconsistent with generally accepted scientific characterization of genome editing. But what the 2020 rule does is it codifies earlier USDA policy for GEOs, a policy statement from March 2018. And it also ends a procedure called Am I Regulated, in which those who develop new products could send a letter to USDA and ask if they're regulated, and the USDA would respond. And there have been 166 of these. Slightly less than half have been GEOs, and most of them, the USDA has declined regulatory jurisdiction. So in March 2018, the biotech regulations, according to USDA, do not currently regulate or have any plans to regulate plants that could have been developed through traditional breeding techniques, as long as they don't have a plant pest and they're not plant pests. And USDA claims to have carefully reviewed the products of these technologies to determine whether they require regulatory oversight. And so what the 2020 rule does is essentially, it does a lot of other things too, but it codifies that USDA statement. So the March 2018 statement indicates that USDA does not plan to regulate deletions or single base pair substitutions. The 2020 rule exempts single deletions of any size and targeted single base pair substitution. Okay, so it does focus on the singleness of these changes. If it's more than one change, then they don't fit within the exemption. So again, the rule, the policy statement from 2018 says the USDA won't regulate insertions from compatible plant relatives and complete null segregants. The 2020 rule, again, compatible plant relatives are exempted. What's interesting is that null segregants are not defined as exemptions because under the 2020 rule, null segregants do not retain modified DNA sequences, so they're simply not defined as genetic engineering under the 2020 rule. So you can see that the policy that was stated in 2018 is codified in the 2020 rule. And there was a lot of emphasis from policy statements from the government dating back to 2011 about that encouraged a more supple regulation for genetic engineering in general. So there are some other exemptions too. One is that there can be additional modifications that could be achieved via conventional breeding. This is the kind of future proofing of the new rule. And there is a regulatory process for adding exemptions, and it will require public notice and opportunity to comment from the public. Other things that are not regulated are plant trait mechanism of action combinations that have been evaluated via regulatory status review, and we'll talk about that briefly, and determined not to be regulated, and things that went through the whole permitting process and got non-regulated status under the 1987 rule. And those plants that aren't regulated under Am I Regulated, that we talked about before, are also exempt from following the provisions of the 2020 rule. One of the controversial aspects of this is that there's a process called self-determination in which developers decide if a new organism is exempt. There's no requirement of notice to APHIS, USDA, which has caused some comment and disagreement. But there is something that's referred to as a voluntary confirmation process. The developer will send detailed information to APHIS and ask if APHIS agrees that the exemption applies. And if so, then APHIS will post a confirmation letter on its website. And USDA in its rules said this should help to market products both domestically and internationally. And there's also a guidance document for developers to tell them how to request a confirmation of exemption. It's true that APHIS has noted that some GEOs will be regulated if they pose a plausible plant pest risk. So every GEO is not going to be exempt. If a GEO isn't exempt, and for other products that are exempt, there is a new process called the regulatory status review. And this replaces the complicated petition for determination of non-regulated status. It assesses the likelihood and magnitude of plausible plant pest risks. Interestingly, it does not require field trial data, although APHIS can request more data, including field trial, to assess risk. If APHIS does not find a plausible plant pest risk, then the GE plant is not regulated under the 2020 rule. But if there is a plausible plant risk pathway, the developer can request a more detailed review or can apply for a permit, or both sometimes. So permits are still in the system, and if the regulatory status review found a likely risk of a plant pest, or it's not certain, or the developer wants a permit, or the GE organism fits in a regulated category, then there might be a permit. And there probably are reasons why developers would seek a permit, particularly in terms of trade. The regulated categories for a permit are a plant trait MOA that isn't evaluated or held to need a permit, an organism that's defined as a plant pest. Products for pharmaceutical or industrial use will always require a permit. And then there's a list of some non-plants or microorganisms with a plant pest risk. And for more information, I'm publishing an article in the European Food and Feed Law Review, probably around the end of the year. It should be out. There are trade issues with all of this, I think. The usual issues about asynchronous approvals and low-level presence. But in terms of gene organisms particularly, a variety that isn't regulated in the United States, but is subject to GMO regulation in the EU will be a problem. Some of these varieties don't leave any markers, which is difficult. And then there are questions about labels, because it seems to me that under our bioengineered food labeling law, these GEOs will not require labels. And then traceability is going to raise some issues too. Regulatory systems differ, and of course, trade is subject to the rules of the importing country. And in the comments from the proposed rule, I think a lot of stakeholders actually feared trade disruptions. Will trading partners accept the US regulatory changes? APHIS is fairly optimistic about this. Trading partners have historically judged our approach to be acceptable because it's transparent and science and risk-based. And APHIS plans to provide technical expertise for trading partners about determinations of regulatory status. And also, there's going to be a lot of public information available. There's an MOA table that's actually already on the website that gives information about deregulated varieties and from the regulatory status reviews. And then the confirmation letters for exemptions are going to be posted, and that's particularly important for genome edited organisms. So, kind of in conclusion, innovations in biotechnology will be important in the future for agricultural production. We need to feed 9.7 billion people by 2050. We need to think about sustainability, climate resiliencies, and other issues. And it seems that precise, affordable technologies are going to be critical, and it's important that our regulatory policies be flexible and proportionate, adaptable to innovation, future-proof sort of, and that they focus on the risk of the organism. And the 2020 rule is really intended to play a role in the future of biotechnology. Thank you for your attention.
Well, thank you so much, Peggy, for this very concise and brilliant talk about the regulation of genome-edited organisms in the United States. But let's carry on before we ask questions. Our last speaker for this afternoon will be Professor Stuart Smythe. He is professor in the Department of Agriculture and Resource Economics at the University of Saskatchewan, and there he holds the chair of Agri-Food Innovation and Sustainability Enhancement. And also he is a highly distinguished expert in the field of agrobiotechnology regulation in Canada, and of course also an expert in the field of GMO law in Canada. So, Stuart, please go ahead. The floor is yours.
Thank you, Hans George. It's good to see you again, and same for Margaret and Martin too. So thanks for the invitation to talk a little bit about how Canada regulates GMOs and gene-edited products. Basically, Canada just simply adapted the existing regulatory framework it had for conventional crop varieties prior to GMOs. So between 1988 and 94, regulatory experts, government scientists, industry scientists, and academic scientists got together and commissioned some reports and looked at the literature, but essentially determined that the 3 acts that governed crop variety approvals in Canada at the leading up into the late 80s and early 90s could simply be adapted, and you can see the different aspects of risk that are assessed under the risk assessment process that Canada uses. So when it comes to gene editing regulation, the same 3 acts will be used to assess the potential for risk from any gene-edited variety. Canada has approved 2 gene-edited varieties, one by CBIS that used ODM to insert herbicide tolerance. There's been very limited adoption over the last 3 or 4 years. And BASF had a herbicide-tolerant variety commercialized a few years ago, but given the global mergers and acquisitions, it's a little bit uncertain as to how much clearfield canola is actually been produced, given the shifting of the clearfield technology from the Bayer-Monsanto merger. So one of the ways that the industry in Canada has signaled some concerns to the regulatory agencies, the CFIA and Health Canada, was that plant breeders and the industry were expressing some concerns about the application of novelties. So 3 years ago, a workshop was held by the 3 groups listed there as organizing it, and really expressing the idea that there needed to be more definition of exactly what was novel, what could be done within the plant genome that would trigger or would not trigger novelty. This is particularly the case for the public institutions, the universities and public sector variety development, because at my university, for example, they don't develop anything that will be a PNT simply because our university doesn't have the capacity to have two parallel streams, one for non-PNT varieties and one for PNT varieties. Our regular plant breeding system is taxed to the margins in terms of land availability, lab availability. So to have a separate parallel stream is just simply not economically feasible. And one of our plant breeders told me that really what drives all variety development is yield enhancement. And there's a great deal of uncertainty about what level of yield increase is going to trigger novelty and result in a PNT. And a couple of the breeders I've spoken to, and one in particular, said that if they get a line of the crop that they're involved in developing, if the yield bump is over 20%, then they make sure that that variety doesn't go forward for commercialization because of concerns about it triggering a PNT. So this lack of definition about novelty is hindering the development of truly innovative varieties, because the varieties that are going forward will have lower yield increases than what might be the case. So since this workshop was held in 2017, Health Canada has initiated and just concluded 2 years of roundtable discussions with industry. They're committed to having public consultations that will begin in January with a full report or program provided by April. I did a survey with about 100 plant breeders, which was about 25% of plant breeders in Canada 2 years ago, and asked them about their use of gene editing, and also whether they viewed the existing PNT regulations as a barrier to their research. So you can see that when we did this survey 2 years ago, a third of plant breeders in Canada were using it, and 2/3 expect to be using it at some point by next year. And most of the leading reason for the wish or the desire to use gene editing was it was going to create a simpler regulatory pathway for commercialization. And you can see that of the public plant breeders, public sector plant breeders that responded to the survey, 100% of them indicated that was their reason for adopting gene editing technologies. Yet as we pushed into the second aspect of the paper or of the research, you can see that plant breeders overwhelmingly hold the perspective that there needs to be a credible review of exactly what PNT regulations are and how novelty is going to be applied. And so you can start to see some of the costs creeping in due to the lack of regulatory certainty. 1/3 of plant breeders had determined that if their variety was going to be a PNT, they ended research on that with that line. Just over 20% have had research proposals turned down due to uncertainty around PNT. And so this lack of clarity around what is going to be truly novel, because within the Canadian system, it doesn't matter what process was used to develop it, whether it was mutagenic breeding, genetic modification, or gene editing. What gets regulated, as Hans Dieter said at the end, is the seeds. The product at the end of the day is what gets regulated. The process is irrelevant. So to give you a bit of an idea, that there's definitely some confusion what is novel, and there needs to be more clarity about that. We're finding that there's a definite barrier to the lack of novelty. And to give you an estimate as to what we think this could be costing the Canadian agriculture sector on an annual basis, there's somewhere between $800 and $1 billion invested in ag R&D in Canada annually. And so with 1/3 of breeders saying that they're ending or halting research programs, we sort of roughly estimate that could be a direct cost of $100 to $300 million. And when these potential varieties are being halted, that are particularly higher yielding varieties, when we extend that to the farmer adoption of new varieties that are lower yielding than what the case might be, based on the the annual value of crop production in Canada, we estimate that the farm level losses could be reaching $1 billion annually. So this lack of certainty about what is novel, what is not novel, particularly as it relates to yield increases, is an expensive barrier within the Canadian ag industry, costing somewhere between $1.1 and $1.3 billion annually. So thank you for the invitation, and I look forward to the questions for the panel.
Well, thank you so much, Stuart, for this very, very interesting and in-depth analysis. Also a brief analysis, but analysis of your regulatory framework and also the effects it has on innovation. That was really quite interesting. But now I think I will hand over to Johannes Fritsch, and he will read out some of the questions. Is that the case, Johannes Fritsch?
Yes, thank you.
Okay.
So there have been several questions. I try to sort them somehow. So there's a lot of questions around trade disruption and how you consider the world trade being major exporters also to Europe. So there's a general question to all three of you. What are the implications of this way of regulating GMOs, GEOs in your own country, and maybe also with a peek to the European interpretation of how to regulate certain organisms that are not being declared a GMO in your own country? And there's one specific question in this area to Martin, if this even, let's see where it was, if this view on the trade disruption plays a role in the process of classifying these organisms as a GMO or not. So I guess you have this clear process, but the question is if with view on the possible trade disruption, if this plays a role in this process. So, Martin, do you want to start?
Yeah. Yes, thank you. So I have seen both questions. As regards to the question by Dr. Detlef Barsch regarding public records on genome edited products, as I have explained, with genome editing, you can produce different kinds of products, and the regulated articles in Argentina are GMOs, and the other articles are conventional varieties that also have their own regulation. So when we analyze a product modified by genome editing, what we do is to decide if it is a GMO or not. So, and each one of those has its own registers. So either you will find them under the GMO registration process and public records, or you will find it under the conventional products registration and public records. We do not recognize a third category, and therefore there is not a third record of gene edited. So it's either, after the assessment, is either a GMO or a non-GMO. Then the other question that was addressed to me by Dr. Hirsch-Kletter is about trade disruption. As you said, it's not easy right now to make a prediction of if there's going to be trade disruption. For instance, in the case of GMOs, we did have trade disruption, and we did have a WTO panel on GMOs. I was part of the Argentine team that was defending the country interest in that panel. So in there, we did have trade disruption and trade dispute. But more recently, in regards to animal cloning, for instance, in Argentina, we had a very different, Argentina, US, Brazil, Australia, we had a certain understanding of the safety and other considerations pertaining animal cloning. In the EU, it seems to be different, and that was perhaps also leading to a potential clash. But in the end, at least what is in regards to Argentine users of the technology, they just decided not to use it in order to avoid any clash with the EU. So In regards to genome editing, we're at a very initial stance. We don't know how many of these products will be on the kind of crops that are exported to the European Union. But also, in my very personal view, the situation in the European Union is not clear. But even when there is this ruling by the European Court of Justice, it has to be taken into account that in the past, national authorities have a very different interpretation when they have to handle applications for field trials. Also, we have official scientific analysis commissioned by European Commission that had a different interpretation. And finally, that the EU is not using the Cartagena Protocol definition. They are using a definition of their own. So if we are heading to a trade dispute, it may be because Europe has to didn't revise its own policies. Thank you.
Thank you so much, Martin, for this explanation. I think there are questions to all our speakers. So we may choose questions to Margaret concerning the US regulatory system.
Yes, so there was also this question to all, how do you see implications for trade disruption? So the same question to Margaret, and there's some specific questions to you. For example, what was the reasoning for this self-determination in this new 2020 regulatory approach? And there's a second one which goes to the same direction, I think. To what extent does the new rule proposed by the EPA align with the rule already implemented by the USDA?
Yeah, as to trade, I raised that kind of briefly in my slides, and I think, you know, because the importing country rules have to be followed, I think there could be some trade disruptions with genome edited crops. So far as I know, there's only one that's planted commercially in the United States. It's a calyxed soybean, and it's grown in a closed loop, so that farmers will plant and sell it to the company. And I read recently that there are some restaurants in Minneapolis that are now using that soybean oil. But as far as I know, that's the only crop being produced commercially. So the trade problems are in the future, but I think the whole question of varieties that leave no markers and you know, the whole questions of labeling and traceability will be really, really difficult in the future, assuming that the EU doesn't create a more supple regulation. Now, the next question has to do with the self-determination and the purpose of that. I think that the USDA decided that crops that are raised or bred in conventional breeding have been subject to very little oversight, and that because the result is similar with GEOs, that like products should be regulated alike. And the self-determination is really focused in part on regulatory relief when it seemed clear to USDA that there was no harm to happen from these organisms. And also, it avoids a lot of redundant evaluation by USDA, so USDA can actually focus its emphasis on the crops that really do need careful evaluation. The other aspect of this is that, in fact, APHIS believes that most developers will actually ask for a letter of confirmation, which is a kind of review, because there will be details about the crop in the inquiry letter, and USDA will have a chance to evaluate it. The question about the Environmental Protection Agency and its proposed regulations, just to give you some background, the Environmental Protection Agency governs genetically engineered organisms that carry pesticides, which they refer to as plant incorporated protectants. And it regulates under the pesticide law, and residues in food are regulated under the Food, Drug, and Cosmetic Act. the regulation that was proposed at the beginning of September still hasn't appeared in the Federal Register. I've been looking for it every day. But it proposes to exempt these plant incorporated protectants based on sexually compatible plants created through biotechnology. That's the language from kind of the summary of that. If there are no greater risks than safe PIPs and they could have been created through conventional breeding, they'll be exempted from regulation. Again, there is self-determination proposed by the EPA, but interestingly, the EPA requires developers either to report to the EPA or to request confirmation. So they propose an additional step that goes beyond what APHIS has set in place. I think that's it. I think I got all those.
Okay, thank you very much, Peggy, for this exhaustive explanation. There's also a question to Stuart Smythe, actually, by Jens Karman. I think we take that.
Yeah. So there's two questions to Stuart. So one is, do you have any suggestion how to more clearly define novelty without being completely arbitrary? And the second question is, let me see, I think it was about, actually, there it is. So what about food from P&Ts that are not regulated elsewhere and that are imported into Canada? Are there examples of any trade issues over this? You're still mute?
Great, thanks for both those questions. So in response to the first one, what has been suggested is that novelty provide an exemption for existing traits in existing crops that have had risk assessments conducted for up to 25 years. So for example, herbicide tolerance in canola, we commercialized the first varieties in 1995. So we've got 25 years of risk assessment with no evidence of ecological, environmental, human harm. So the idea would be is that if gene editing resulted in the development of another herbicide tolerant canola variety, it would be exempt. However, if a breeder was developing a new trait within an existing variety or a new novel trait within a new variety, then that would undergo the full risk assessment. And in response to the second one, so what Canada does is our regulatory agencies do conduct risk assessments on crops and food products that could never be grown in Canada. So we've approved genetically modified papaya, we've approved golden rice in the example of rice, in case some golden rice commingles with other rice, then if it's detected in an import into Canada, we've already conducted a risk assessment and approved it, so there are no trade disruptions. So the Canadian regulatory agencies have been quite realistic of potential trade disruptions and conducted risk assessments on crops that simply would never be grown within Canada, but certainly would be a common import.
Okay, thank you. There are some very specific questions, if I may, or Professor Dera, you have a question?
There's one question actually to all three speakers by Kai Purnhagen. Perhaps we may ask this question to all three speakers. Are there any possibilities in the legal systems presented to take into account potential and yet unknown future benefits in the regulation of GMOs? So on the question not about risks, but rather to benefits and how they are taken into account, even if they are only potential and yet unknown. Would anyone like to ask or give an idea? Margaret was first.
Sure. Well, I mentioned in my slides that in the new USDA regulation, there is this future proofing that actually allows for new exemptions. And presumably that is to have a process so that new GEOs, for example, things that could be achieved through conventional breeding, can be accommodated in the system. Now, when you look at these regulations, the focus is really plant pest risks. There really isn't the focus on the social economic benefits from genetically modified organisms or genome edited organisms. So the regulation, I think, doesn't actually focus on benefits, it focuses on an analysis to determine if there's a plant pest risk, and that's the authority that USDA has. And I think our system is a little bit different in the sense that those social economic issues probably don't come into the regulatory decisions quite as much as they do in Europe. I'm not sure that that totally answers your question, Kai, but it's an attempt anyway.
Kai, one of the things that we've seen in Canada is that the social aspects don't come into play. So I don't think, as Margaret said, I doubt that in Canada we would see a change in the science-based risk assessment to begin to bring that in. But when I've talked to companies that have submitted GM varieties for risk assessment, what they're doing is they're taking some of the studies that have been done by academics that quantify environmental benefits, such as the reduction in tillage or the reduction in chemical use or those types of impacts. And the references to those studies get included in the compendium of data that gets submitted as part of the dossier for a risk assessment. So that information is being provided to regulators to say that herbicide tolerant varieties are reducing the impact on the environment, and here's the sort of the research from agricultural economists that have quantified some of that. So we do, or I've heard some evidence that those aspects are at least being included in the submission dossiers for risk assessment.
Great, thank you. Stuart, would like to add? Yes, please, you're welcome.
Thank you, Hans-Georg. Let me paraphrase something that has been said and now something else. If a product, GMO, gene edited, whatever, if a product has a risk, and we are talking here of sanitary regulatory regimes in any of our countries. So it's a sanitary regulatory regime. And if a product has a risk, you cannot compensate by a social or economic benefit. So that's it. Only after a product has been assessed as safe, perhaps you can have pros and cons. For instance, in the GMO in Argentina, we have a socioeconomic or productive commercial assessment where we weight pears and apples between the possibility of exporting to countries and the benefits. Sometimes countries have not approved the product and therefore we cannot export there, but at the same time we may have more productivity and we outweigh pears and apples. But that's an assessment on itself after the safety assessment has been done. And as Stuart said, perhaps while if you're doing the safety assessment of a product right, you may compare with the adequate counterpart. And in case a product, for instance, if you have a BT crop, you should not only compare against the wild type or conventional crop of the same kind. You should also compare to the use of chemical insecticide. And perhaps there indirectly you are assessing a benefit because your product is less, it has less risk than the conventional or the counterpart. But when it comes to gene editing in particular, I think it's more valuable to focus on the potential benefits, not as part of the assessment of product by product, but in the policy making stage. So if we approach the benefits to the policy makers, perhaps they will make a stronger effort not to over-regulate the products in general. I mean, the general benefits be used by policymakers to find the adequate regulation and not to over-regulate in general. Thank you.
Thank you so much, Martin. Well, we are just 1 minute before 5 p.m. here. Dr. Fritsch, what do you think? There's one more questions which could be addressed, or is addressed actually, to all three speakers, and that would also provide all speakers with the opportunity to make a sort of also a final statement at the same time. Should we proceed like this? What do you think?
Yeah.
Is that okay? So this is a question by Adinda de Schrijver, and she refers to the title of our webinars, and the question is to all of you: do you see any new international disputes arising compared to conventional GMOs if the EU does not exempt genome-edited organisms? Or will the same as for conventional GMOs will be repeated, e.g. a World Trade Organization, WTO dispute? This was the question. So do you see a possibility of new trade disputes unless the EU exempts genome-edited organisms from regulation? This is only a starting point, perhaps, for a final remark. Stuart, you would like to start? Okay.
Sure. Thank you, Hans-George. I'm just going to take a second and address the one question about the Cibus variety that was commercialized. So in Canada, the way the canola trade industry works is that any new variety that comes on that is a PNT the developer has to ensure that it receives import approval or risk assessment approval in the key export markets. So China, Asia, other parts of Asia, Europe, Mexico Cibus would have ensured that it had passed the risk assessment system prior to commercialization. That's sort of the agreement that the canola industry has come to. So to turn to this last question, I think the challenge, particularly for the EU, is going to be, given that there's no testing capacity, they're going to find themselves in a similar situation to what they were in 2007 and 8, shortly after they made sure that no further GM crops were going to be commercialized in the EU, and they were scouring the globe for non-GM corn and soybeans for use as livestock feed, and were quickly running out of sources. And I remember being at a conference about 2006, and there was a representative from the Brazilian Farm Association, and he estimated that 80% of Brazil's corn and soybean exports to Europe were GM, whereas the delegate from the Brazilian Ministry of Agriculture said it was only 10%. So I think if Europe tries to ensure that gene-edited products have to be the same way as GM, and with no testing capacity, really the default position for the EU trade imports comes to reject if they can't guarantee that there's no gene-editing varieties in a shipment, because there's no other option. Without the ability to quantify and determine what percentage gene-edited varieties might be in any shipment of corn or soybeans, the default has to be to reject. And Europe would, within a few months, run out of supply or access to, down the road, not right away, but say in 3 to 5 years, when more gene-edited varieties are released, that the supply of varieties that would be acceptable into the EU for livestock feed could rapidly be reduced, and which would result in pushing up meat prices across the EU. Thank you.
Would you like to add something also regarding the question of international disputes?
Sure, I can say something. I mean, I think it's possible that there could be international disputes. I would hope that it wouldn't get to the level of the World Trade Organization. And I think that's probably remote, at least until a number of these products are commercialized and grown in quantities for export. I do think that the companies that are exporting to the European Union are making an effort to get the proper authorization in the European Union. I'm wondering if for GEOs, that's going to be more and more difficult because, as Stuart just said, of the problem with testing and finding out if those things really are from conventional breeding or GEOs, and there may even be a problem for the developers to get a unique identifier so that they could fit into the traceability system. So I think there could be problems in the future, and I hope, like many, that the European Union will enact some sort of a provision, perhaps along the line that Leopoldina has suggested, to regulate these crops differently. That's my hope. And in the long term, maybe a different GMO regulation would be great. Thank you.
Well, thank you so much, Margaret. Well, and last but not least, Martin also raised his hand. Please,
thank you,
Martin, go ahead.
And is it possible that this is leading to a trade dispute? Possible, yes. Probably, but this probability, I don't know at this instance. But if, in case there is a trade dispute, as I said, I understand that the legal base of the EU defending itself in a WTO case is quite weak because, among other things, the use of a very special GMO definition different from the international standard, and also because there are conflicting interpretations of that definition even within the official bodies of the European Union and its member states. But besides that, it's not just about possible trade dispute that the EU should think about revising or updating its regulation. It's also about all of the benefits, the social benefits, environmental benefits that these kind of technologies could bring to countries outside of the Union, but also within the Union, if now biotechnology sector seed companies are allowed to deliver these products to the agricultural farmers. Thank you.
So thank you so much, Martin, for this last remark. Okay, so I think we're at the end of this session, also almost at the end of the conference. And thank you so much to all of you for your exciting talks, and also to all the participants and the audience for the very lively discussion at the end of these 2 days. And thank you also for these comprehensive and enlightening statements and answers by the speakers. What I found interesting actually is how successful the Argentine and also the US system are when it comes to the regulation of GMOs, but also in particular the NPT organisms resulting from genome editing. When I look at the high diversity of organisms, high diversity of traits, and high diversity of applicants that was described by Martin Lehmer regarding the Argentine regulatory system, that is really astonishing. And I think the same applies to the United States. There's a similar variety of organisms, traits, and applicants, actually, when you have a look at the list of unregulated articles in the MI-regulated procedure. What I've found a little bit concerning, actually, is, or worrying, is Canada with its problem of novelty and the question of legal certainty. What is novelty? What is the meaning of novelty? And that lack of legal certainty could even prevent innovation. That was one of the messages, actually, I think I got from your talk, Stuart. That was also quite interesting to hear. So what we see in the end is actually that there's still that regulatory asymmetry between our transatlantic trading partners, Canada, the United States, Argentina, and many other South American states on the one side, and the EU on the other side. And I think the call should be a call for a more harmonized regulatory approach globally, actually, and that would require more and enhanced regulatory cooperation among these trading partners. So we got many ideas, of course, how to adjust our system in the European Union. And what I see in all three countries here, Argentina, United States, and Canada, is that I think the regulation is much more science-driven than in the EU. But let me stop here and thank you all. Thank you once again. Thanks all to you and to the all participants, discussants, and the audience as well for all their interest and questions. And I think I will now hand over to the organizers, to Dr. Fritsch, and that also means I have to thank the organizers for the excellent presentation of this conference, which I think was really a great task. It was an enormously great job. Thank you so much.
Yeah, thank you very much. Also in the name of Leopoldina and DFG, the two organizers of this international conference, I'd like to thank all the panelists and moderators for giving us their time and expertise, and also the attendees for all their attention. We actually had almost 500 attendees from more than 40 countries, very different time zones. Some people obviously got up in the middle of the night to see some of the presentations. I hope we were able to shed light on very different socioeconomic, environmental, political, and last but not least, scientific aspects of this very complex topic of regulating genome edited organisms, or genetically modified organisms, as you may call them. Yeah, thanks again for your attention and all your questions. I'm very sorry that we couldn't give all the questions to the referees. There were always too many in each session, and we had to sort them somehow. There were many people asking for the slides of the presentations. We will have all the videos and the slides on the website of the conference. You can see, or you can find the links on www.leopoldina.org/en/EU-genome-editing. And also in the conference program at the very end. Yeah, in the meantime, feel free to follow and retweet our postings on social media, and follow our ongoing work in providing independent, science-based advice to policymakers and citizens. I hope we will see you again at some other conference in person or virtually. And on behalf of the organizing team, I will want to give you our warmest regards and all the best wishes. And the conference is hereby closed. Goodbye and stay healthy. Bye-bye.